Hello, and good morning to Ashford's weekly webinar addressing your questions concerning COVID-19 related issues. This morning I'm joined by Alan Bennett, a partner in our restructuring and insolvency team, and by James Hensley, a partner in our property litigation department. Good morning to you both.
Morning.
I have a question for each of you this week, starting if I can with James. Our inquirer asks as follows. I'm a commercial landlord and I let a warehouse premises to a tenant. The lease came to an end last week, but the tenant has advised that they cannot remove their stock due to the restrictions, so they're therefore still occupying the premises. What can I do?
Thanks, Andy. The first question is to consider whether the tenancy is protected by the Landlord Tenant Act 1954, so whether it's a business tenancy. If so, there's probably quite a strong argument that the tenant's holding over under the Act, under the same terms as before, and that the tenancy can't be brought to an end unless the tenant or the landlord serves the appropriate notices under the Act. I'm not going to go into the detail of that today because it's quite far-reaching. But I think the advantage in that scenario for the landlord is that the tenant will still have to pay rent whilst it's in occupation. So I think the landlord is in quite a good position there whilst the current lockdown is going on. The situation is slightly different if the lease is not protected by the Landlord and Tenant Act. I think in that situation the landlord has a couple of potential options open to it. Firstly, there's a good argument that the tenant, as it remains in occupation and hasn't been able to provide vacant possession, the tenancy at will may have arisen on the same terms as the prior lease. This would mean that the tenant would have to continue to pay rent for its occupation, and the landlord can take steps to terminate the tenancy at will when it needs to post-lockdown. Normally with a tenancy at will, the landlord just needs to serve what's called reasonable notice, and that will depend on the circumstances of the case. But obviously after the lockdown, it gives the landlord the opportunity to be able to then take back the premises and use it as it wants to. The landlord needs to be slightly careful that it doesn't inadvertently create a periodic tenancy which would become protected by the Landlord and Tenant Act. But if it's short term and the landlord's clear in the terms that are provided, then this can easily be avoided. But I'd recommend that you come and speak to us and that we help you document that arrangement so as to avoid any future problems. The second possibility for the landlord is to change the locks and terminate the tenancy. Obviously, there's practical difficulties with that at the moment, but we do know that commercial bailiffs are continuing to carry out work. As a tenant will still have stock in the warehouse, the landlord just needs to be careful what he does with it. It's not easy. It's not just necessarily the landlord can go in, remove the stock, sell it, and do what he wants with it. The landlord should give the tenant the opportunity to come and get his stock. Otherwise, if the tenant doesn't remove the items, then the landlord can serve a notice under the Torts Act, which enables it to remove the items and then sell them. The landlord can take its costs from taking that action from the proceeds of sale. But as I said before, it's something that the landlord just needs to consider the practical difficulties of that, and it may be something that in a few weeks' time, when the lockdown starts to ease, that the landlord may want to consider doing. Finally, there's nothing stopping the landlord and tenant from discussing a new short-term arrangement, given the circumstances, either in the form of a lease or a license allowing the tenant to leave the items stored in the warehouse during the lockdown, and arrangements provided for that stock to be removed at the end of the lockdown. Again, as I said before, with the tenancy at will arrangement, you would just need to make sure that's carefully documented to ensure that the landlord doesn't inadvertently grant rights to the tenant for its future occupation.
Okay, thanks, James. It sounds like there's lots that can be done, but it's really important to take advice and make sure you get it right.
Yeah, that's correct, Andy.
Okay, thanks. On to Alan. Alan, I've got a second question from our inquirer. The question is, I understand that there is a moratorium on landlords issuing statutory demands and presenting winding up petitions at present. Does this mean that I'm excused from paying rent over the coming months?
Thanks, Andy. So I guess the starting point really is need to differentiate between the statutory demand and the winding up petition. So firstly, a statutory demand is just a demand to pay. It gives you 21 days to pay, and then after that period, the landlord can present a winding up petition in ordinary circumstances. So it is not a court document, and so it is not entirely clear how anybody could stop anybody from serving a statutory demand, and it's also not a prerequisite to a winding up petition either. Secondly, winding up petitions, they are typically presented to the court then issues them, and then they are served. The court have announced that there is a ban on presenting petitions. However, no legislation has yet been passed. There was a recent decision called Short Gardens LLP, in which Mr. Justice Snowden looked at this issue, and he was very much of the opinion, while there was no legislation, that the proposals probably only covered specific sectors such as retail and hospitality, and only when they are affected by COVID-19. And so it would appear that the general rule is that you cannot present a winding up petition in those circumstances. But equally, the guidance does talk about having the ability to get permission of the court to present the petition if there is reasons why that landlord can pay. That tenant can pay. And it's a very difficult balance. I think the whole essence behind what the government are trying to put in place is to try and have an open dialogue with between landlord and tenant, and have a differentiation between those that cannot pay and those that won't pay. And really, tenants will be well advised to negotiate fairly with their landlords and look to see whether or not there can be reached some sort of compromise between the landlord wanting to be paid everything and the tenant wanting to pay next to nothing. So certainly I don't think it is a complete bulletproof shield that some tenants think it may well be. Landlords probably will have a little bit more difficulty in terms of presenting petitions, but yes, it's one of those tensions that everybody's got to act as fairly as possible to come up with a reasonable outcome.
Thank you both to you for joining us today and for answering those questions. If you would like to raise a question for a future panel, then please do so. Send in your questions to us here at Ashfords at events@ashfords.co.uk. That's events@ashfords.co.uk, and we'll assemble a panel to deal with those questions. And we look forward to seeing you on a future webinar. Thank you very much. Thanks both.